Today, we are going to discuss on the topic International Standards, Norms of Human Rights during the Emergency. The idea of human rights has evolved through a long historical process. It has evolved through surpassing customs, cultures, traditions, etc. Modern definition of human rights has originally talked about unlimited freedom of individuals, whereby the state was to play the role of a night watchman. The unlimited scope for individual freedom was restrained and subject to some kind of contract which gave birth to the notion of legitimate authority. The practice of human rights began to be increasingly subsumed and defined by the authorities called states. It is no wonder to have suspended several aspects of human rights when the authorities are convinced to do so. The suspension could come in the name of emergency or exceptional environment of politics. What exactly constitutes such an environment is largely a prerogative of states. Safeguarding of human rights has been a delicate subject matter in the deliberations of the United Nations. In order to safeguard and protect human rights from any whimsical onslaught, the United Nations has established international standards, norms of human rights, especially with regard to emergency situations. Certain human rights treaties envisage a system of derogation allowing state parties to adjust their obligations temporarily under the treaty in exceptional circumstances, that is, in times of public emergency. Examples of emergency situation include armed conflicts, civil unrest and natural disasters, etc. Enabling the state to come up with exceptional measures, there are a number of conditions set by the treaties of UN. The conditions are to check severity and possible permanence of states' undue prerogatives. The perspective of UN on the derogation procedure aims at ensuring a balance between the protection of individual rights and protection of a member state's national needs. The balancing act is to pose reasonable limits on emergency powers of a state. Whether to derogate and accord powers on the subjects under discussion here are provided in various UN legal proceedings. The Article 5 of the Geneva Convention 1949 also consists of a number of disclaimers on who would possibly not enjoy the protection of rights of non-derogations. The Article 5 argues, I quote, "Where in the territory of a party to the conflict, if it is satisfied that an individual protected person is definitely suspected of or engaged in activities hostile to the security of the state, such individual person shall not be entitled to claim such rights and privileges under the present convention as would, if exercised in favor of such individual persons, be prejudicial to the security of such state." Unquote. It is evident that the issue of derogation is a dicey subject, often leaving a lot of room for the states in power to handle in their own interests. The Article 4 of the International Covenant on Civil and Political Rights, also known as ICCPR, the Article 15 of the European Convention on Human Rights, ECHR, and Article 27 of the American Convention of Human Rights, ACHR, also deals with derogation matter. The actual source and the most important guidelines on derogation issue comes under the scanner of Human Rights Committee, also known as HRC. HRC is the body of independent experts that monitors implementation of the ICCPR policies. HRC looks after possible derogation of rights under the following select, special and extraordinary arrangements. HRC guidelines conceptualize the possibility of derogation if there exists the following realities. To discuss this point, the existence of a situation amounting to public emergency is a fundamental requirement for invoking the derogation power. Interpretations of the concept of derogation come from the HRC and ECHR. In the opinion of HRC, not every disturbance or catastrophe qualifies as a public emergency which threatens the life of the nation. According to ICCPR, civil war and violent internal unrest are the most asserted reasons for declaring a state of emergency. An important example which can be cited in this regard is the European Court of Human Rights, also known as ECHR, in Lawless versus Ireland qualified the time of public emergency as an exceptional situation of crisis or emergency which afflicts the whole population and constitutes a threat to the organized life of the community of which the community is composed. The concept of public emergency is further developed by the European Commission on Human Rights on the following grounds. 1. Must be actual or imminent. 2. Involve the whole nation. 3. Threatened situation of community life. And 4. Existence of an exceptional crisis involving public safety, health and order. The requirements of proclamation and notification are important for the purpose of national and internal supervision. The ICCPR requires an official proclamation of the existence of a public emergency, which is an essential technical prerequisite for the application of derogation. General Comment 29 specifies that the states must act within their constitutional and other provisions of law that govern such proclamation and the exercise of emergency powers. During this time, there occurred a milestone constitutional development in India. The 44th Amendment Act of the Constitution of India amended Article 359 of the Constitution to provide that even though other fundamental rights could be suspended during the emergency, rights conferred by Article 20 and 21 could not be suspended. The duty to proclaim should be distinguished from the duty to notify under Article 4, Clause 3 of ICCPR and Article 15, Clause 3 of ECHR. The duty to proclaim the state of emergency is designed to prevent arbitrary or de facto derogation and to obligate derogating states to act transparently. The notification requirement serves as a guarantee for supervision by international bodies of the legality of the establishment of a state of emergency. State parties to the covenant are bound to inform other parties immediately. Notification process also seeks sufficient and precise information about a country's legal practice in the field of emergency powers. However, many level charges against the notification process as not properly preempting a violation of human rights. Derogation measures must be limited to the extent strictly required by the exigencies of the situations, that is, they need to be proportionate. The requirement of proportionality constitutes one of the substantive limits to the emergency powers, requiring specific scrutiny and evident justification. HRC highlights three factors in proportionality matters. One is about severity, second, duration, and third, geographic scope. Consistency is an important premise for practicing derogation measures in the international law. Consistency is to ensure better practice of derogation powers. It is important to underline that there is no concept of derogation in humanitarian law. As such, since international humanitarian law is designed in essence to operate in emergency situations, the obligations stemming from humanitarian law treaties generally cannot be derogated from. Other related obligations also include Convention on the Status of Refugees and its 1967 Protocol, Convention on the Rights of the Child, International Labour Organization Convention on Forced Labour, Freedom of Association, and Equal Rights of Workers. The Article 5, Clause 1 of the ICCPR states, I quote, "There shall be no restriction upon or derogation from any fundamental rights recognized in other instruments on the pretext that the Covenant does not recognize such rights or that it recognizes them to a lesser extent," unquote. Similarly, the principle of just causes is enshrined in the Article 53 of the Vienna Convention on the Law of Treaties, 1969. Rules of just causes generally require or forbid the state to do particular acts. Generally included on the list of such norms are prohibition of internationally wrongful acts such as waging war, war crimes, crime against humanity, piracy, genocide, apartheid, slavery, and torture. As far as the armed conflict situations are concerned, international humanitarian laws have not entirely resolved the moot issue on differentiating what is derogation and non-derogation powers. It gives ample room to the states that it may resort to the use of potentially lethal forces where absolutely necessary, and may use that amount of force which is necessary to deal with the threat posed. For example, according to the Principle 9 of the UN Basic Principles on the Use of Force and Firearms by the Law Enforcement Officials, 1990, that targeted killings are not necessarily unlawful in occupied territories. Existence of armed conflict does not automatically lead to derogation unless it threatens life of the nation. Critics have argued that there is a serious risk of abuse and manipulation by the occupying states as to what would constitute absolute necessity and amount of force to legitimize targeted killings. To cite an example, the alleged derogation of human rights almost amounting to genocide by the Sri Lankan government's war against the rebel group Liberation Tigers of Tamil Eelam, also known as LTTE, is a continuing task to be resolved before the United Nations Human Rights Council even today. The nature of any derogation can never authorize acts of genocide or crimes against humanity as enshrined in the Article 12 of ICCPR. In addition, the protection of minority is termed as non-derogable according to the Article 27 as well. The Geneva Convention directs that those who do not take a direct part in hostilities are entitled to respect for their own lives and their moral and physical integrity. The Convention of 1949 also forbids killings or injuring an enemy who surrenders. Protection under Geneva Convention covers medical establishments, transports, and other relevant equipment. Thus, from the above discussion, it can be said that one of the fundamental concerns of protecting rights from derogation has been to uphold prohibition of discriminatory practices. The concept of emergency has been dominantly defined in the interests of the states, no matter if they are all signatories of UN humanitarian treaties. International discourses on human rights to be safeguarded during the emergency have been contested as the international norms and standards do not convincingly tally with the approach of a state. It is often seen that several extraordinary legislations and institutions are set up to counter dissenting voices which are seen as anti-state. In the case of Armed Forces Special Powers Act 1958 in India and Patriots Act 2001 in the United States have set precedents of human rights violations, ironically in the name of a state's integrity and safety. Such acts can be said to have caused inhuman experiences which needs to be made more human, as acknowledged by Dr. Manmohan Singh, the then Prime Minister of India, in 2004. In the days to come, options for effective remedy against violations, judicial accessibility, and fair trial are issues to be given primary importance, even if in cases where rights are to be derogated in potential conditions of emergency.